It's Nolan. I said I'm A-Town finest, so put my game down, grinding. Was on them Greyhounds trying to get out of state. My assignment was hit the stage at a college, encourage kids they could do it. Told them how to reach greatness, some days you must be secluded. On my own shit, hang up the phone shit, they on some clown shit. I'm David, I stay with a stone for cracking your dome with. Play me, I come to your home and ring your alarm. Bitch, I'm crazy, this ain't just a song. Quit raising your tone, prick. I'm that nigga that number one spot, nobody can't top, I ain't even got job though. Big dog gon' run in my block, got the blade on chop, beat nigga like Nacho. Rent do nigga sell like rock, move bass, I not do me like Rocco. Spend a bitch, she say I'm guapo. No money, I say no hablo, no English. My screenplay, try to get stretched out like Bengay. Don't call me, let you and your friend on the line, try to put it on three-way. I'm Green Bay, I'm about my cheese, nigga run up the check like relay. Got leeway, I flip my style like I'm a lucha libre. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everyone is doing well out there. In this particular video, we're going to be getting into Miss Megan Thee Stallion, giving y'all a couple of updates on her current legal battles. I won't even call them legal battles, but her current legal disputes that she's having with a couple of different people. We're going to address the proposed trial date that's being put on the board for Milagro Grrrls, and we're also going to address the update in the case with Megan and Emilio Garcia, aka Emilio Coochie. Just the other day, we went through that entire document about her legal team coming out and saying that Emilio and his legal team have been wasting their time. They did not show up to the court date in New York, and basically tried to petition to the judge for them to be sanctioned so that they should have to pay penalties. And it looks like the judge has confirmed that those sanctions will be pulled and that Emilio Garcia's team will have to pay up some sort of fines for their delinquency and their failure to show up and failure to find legal counsel that can help represent him in the state of New York. So we're going to go through that as well. All right. We're just going to update both of those because both things are happening simultaneously. I'd rather not do multiple videos. So I just want to put it all in one place where y'all can engage and we can talk about it. All right. So first, let's address the Milagro situation. It's not a lot to be addressed here, but we will address it nonetheless. All right. Shout out to Megan Cuniff once more. She says we have a proposed trial date in Megan Thee Stallion cyber stalking lawsuit against Milagro Cooper. The proposed date is July 21st, 2025. The parties will explore the possibility of a settlement in good faith. However, it is premature to address whether settlement is likely. Now, remember, this is a lawsuit that Megan Thee Stallion put out on Milagro. So if there's any settlement to be had, that will be money coming from Milagro to Megan, not the other way around, okay? Just want to be very clear about that from the jump. Give me a second here. I'll share my screen. We're going to go through this quickly. It's not a lot to go through, so cool. All right? So here, this is part of the document. United States District Court, Southern District of Florida, Megan Pete, an individual. Plaintiff versus Milagro Elizabeth Cooper. Defendant. Jury trial is demanded. They say joint scheduling report pursuant to federal R7 P26F and local rule 16.1B. Counsel for plaintiff Megan Pete and defendant Milagro Elizabeth Cooper. And together with plaintiff, the parties conferred on November 12, 2024 and have mutually agreed to the following proposed scheduling report. Meeting of the parties. Pursuant to local rule 16.1B, the parties met on November 12th via telephone conference in which the following participated. Name, Mary Henderson, Esquire, plaintiff, counsel for Megan. Daniel Humphrey, Esquire, also plaintiff counsel for Megan. Then we have Michael Hayden, Esquire, defendant for Milagro. Parties statement of the case. Plaintiff Megan Pete, a Florida resident, brings 4 claims against defendant Milagro Elizabeth Cooper, a Texas resident, for violating section 836.13 Florida statutes. Count one, promotion of an altered sexual depiction, violating section 784, 0485, Florida statutes. Count two, cyber stalking, intentional infliction of emotional distress. Count three, and invading her privacy, false light. Count four, plaintiff denies these claims. All right. And we already went through all of that. Megan is saying that she's been putting these things out there, and these are the things that she did to her. They say, summary of uncontested facts. The possibility of the parties agreeing to factual admissions is unknown at this time, although the parties will endeavor to provide admissions of fact and stipulations regarding the authenticity of documents and other issues prior to trial. Settlement likelihood. The parties will explore the possibility of a settlement in good faith. However, it is premature to address whether settlement is likely. Initial disclosures and likelihood of additional parties. Plaintiff states that, based upon her current understanding of the issues, the appearance of additional parties is unknown at this time. Case track. The parties propose that this case be assigned to the standard track pretrial schedule in accordance to the standard track. The parties propose the following preliminary case deadlines. Okay, so they got a list of dates here to go through so that they can stay on track. So November 26th, exchange of initial disclosures within 14 days of ruling on motion to dismiss, joinder of parties and claims and amendment of pleadings. November 12th, that's already passed. Fact discovery to commence. June 16th, 2025, Rule 26A3A, a pretrial disclosure, i.e. trial witnesses and exhibits. March 14th, 2025, parties to exchange expert reports. March 28th, parties to exchange rebuttal expert reports. April 21st, 2025, close of fact discovery, close of expert discovery. May 19th, dispositive motion deadline. June 23rd, 2025, deadline to file joint pretrial stipulation, joint proposed jury instruction, joint summary of motions in limine. July 7th, 2025, pretrial conference. July 21st, 2025, or as soon thereafter as the court is available, the actual trial. So this is your outline of what you can expect. These things could change, but this is the roadmap to the trial between Megan Thee Stallion and Milagro, right? So just giving y'all the update here as it's available. Furthermore, it is stated that they are waiting on the finalization of Milagro's legal team. She has one lawyer, who we just said, Michael Hayden, who also represents Tory Lanez in his appeal. Hayden has been a licensed lawyer in California since March of 22. However, he's not licensed in Florida, so he will need to find local counsel. All right, so this is the second person that Megan is having some legal dispute with that has an out-of-state legal counsel lawyer that is not licensed and not barred to handle the legal case in the state in which it's being held, right? Emilio Garcia, his lawyer is not licensed in New York. He's having some trouble finding who he needs to help him get on track in there. Milagro is having some of the same issues in Florida. Okay. Furthermore, it is stated from Megan Cuniff, she says Milagro's attorney, Michael Hayden, failed the California State Bar exam 8 times. Hey, you messy. Damn it, man. Failed the bar exam 8 times after graduating from an online, unaccredited law school in 4 years and 4 months. The school wasn't even credited. What the fuck? And I guess there's a video in which he discussed his incredible journey of perseverance on a legal podcast. Now, I ain't gonna throw him under the bus all the way for failing, because I'm guessing he passed it eventually, right? He is licensed in the state of California. So however many times you got to take that shit, the bar ain't easy. You know what I'm saying? Some people fail that motherfucker 3-4 times. Some people, you know what I mean, fail it twice. A lot of people don't get it the first time. So I'm not going to just all the way dispose and shit on homie. but 8 times sounds excessive. Woo. Hey, like my baby say, good luck. Yeah, damn, man. And just to be clear, this Michael Hayden is from the what is this organization? Unite the People. The same organization that was putting out false information surrounding the innocence of Tory Lanez and all of that stuff that's going on. And yeah, this is the same person. So I don't know how this is gonna go, but it doesn't look good for Milagro. I gotta be honest, and that's not coming from any space of bias. It's just that you're coming to the table generally unprepared. You got a clown representing you. I understand, everybody doesn't have money for the top notch legal representation, but that top notch legal representation is typically what helps people. You know what I'm saying? But wow, I don't even understand why Tory Lanez would have accepted these motherfuckers into his circle as high profile as he is. But I guess he felt like he got David Kenner, who's like the fucking maestro at getting people off on high profile cases, and it didn't work out. So I guess he said, shit, if I paid top dollar for him, I might as well pay bottom dollar for the rest of my shit. Again, I'm just looking at what's really going on. It's a lot of questionable decisions being made, and hey man, I guess that's all you're really left with when you're gonna probably lose anyway. And I think the world knows that. But let's get to Emilio situation, right? Because again, just the other day we went over the situation, and he's having a rough time because his legal counsel didn't show up for him in court. He didn't show up, and they're facing ramifications of those actions, okay? So I'll go ahead and share my screen with y'all once more. This is a short document. It's only about 6 pages. We may go through half of it, not the full thing. But I like to show y'all what's going on. So in this situation, Emilio Garcia, plaintiff versus Rock Nation, defendants, etc. They say background. In an order dated October 7th, the court ordered that counsel for all parties participate in an initial pretrial conference on November 6, 2024 at 4 p.m. in courtroom 12C, Daniel Patrick Moynihan Courthouse, 500 Pearl Street, New York. On that date, the court issued an order moving the location of the conference from room 12C to room 26B. On November 6th, the court staff, the reporter, and counsel for defendants appeared in courtroom 26B at the scheduled time, but plaintiff, Emilio, failed to appear. Counsel for plaintiff attempted to call into the court's dedicated conference line at the time scheduled for the conference, but the conference scheduling orders did not permit parties to call into the conference. Plaintiff did not make a request to adjourn the conference prior to the scheduled time. On November 6th, the court ordered counsel for plaintiff Ronaldo Leonardo Zambrano, which is the lawyer of Emilio, to show cause why he should not be sanctioned for violating the court's order and failing to appear as scheduled at the November 6th conference. Mr. Zambrano filed a responsive declaration on November 12th. Defendants filed a response to Mr. Zambrano's declaration on November 15th. That's Alex Spiro and Co. They responded. So here we have legal standard. A district court has inherent power to sanction misconduct by an attorney that involves that attorney's violation of a court order. Where misconduct involves violation of a court order or other misconduct that is not undertaken for the client's benefit, the district court need not find bad faith before imposing a sanction under its inherent power. Okay? District courts, acting pursuant to their authority under Rule 16F, are free to design the sanction to fit the violation, and their focus need not be limited to compensation of opposing counsel. Further, federal civil, whatever these codes are, provides that instead of or in addition to any other sanction, the court must order the party, its attorney, or both to pay the reasonable expenses, including attorney's fees incurred because of any noncompliance with this rule unless the noncompliance was substantially justified or other circumstances make an award of expenses unjust. Meaning, they finna make your ass pay. Conduct is substantially justified if there was a genuine dispute or if reasonable people could differ as to the appropriateness of the contested action. Substantial justification is determined by an objective standard of reasonableness and is not required that a party acted in good faith. An attorney's failure arising out of negligence or sloppiness, ooh, I like that, negligence and sloppiness, will not excuse a violation of Rule 16. Discussion. The court finds it appropriate to sanction Mr. Zambrano pursuant to Federal Code Civil 16F. The court does not find that Mr. Zambrano's failure to attend the November 6th conference was substantially justified. They rejected your deposit. The court's orders make clear that the November 6th conference would be held in person, so his erroneous assumption that he could attend the conference via telephone was not substantially justified. He knew that shit, and he knew he wasn't legally justified to show up in court because it wasn't going to hold no weight. Therefore, he tried to call in. Let's be real about this thing. But let's continue. The court's October 7, 2024 order clearly stated that the conference will take place in courtroom 12C, right? So they give you the address and location and the room in which this will take place. However, he still chose not to go and thought he could call in. The court's order November 5th clearly stated that the conference was being moved to courtroom 26B. Nothing in the court's individual rules of practice in civil cases implies that a party can attend an in-person conference over telephone. Individual Rule 2C states that only the court may designate that a conference will be held telephonically, and that in those cases, the parties should call into the court's dedicated conference line. So you would have needed the judge to grant that first, which you never even did. Mr. Zambrano was not substantially justified in reading from this rule that he could attend an in-person conference by calling into the court's dedicated conference line. Nor does Mr. Zambrano's difficulty with ECF substantially justify violating the court's order by failure to appear, request an adjournment, or otherwise inform the court that he would not appear. So they're saying whatever difficulties you had with getting into the ECF notification system, which was the system telling them about the updates, for whatever reason, he claims he couldn't get access to it. But they say that shit ain't our fault. Boy, oh boy. First, Mr. Zambrano, as counsel for plaintiff, is responsible for monitoring communications regarding her client and case, which includes checking the electronic docket after his client's case is transferred to this district. Second, after Mr. Zambrano emailed the court's chambers on October 24th asking for assistance with ECF notifications in violation of the court's individual rules, the court's chambers replied that same day by reminding Mr. Zambrano that all communication with the court must, by default, be made by letter filed on the docket, and that the court's individual rules direct counsel to the court's ECF help desk for questions regarding the system. It was Mr. Zambrano's responsibility to use the resources to which he was referred in order to ensure he received ECF notifications. Third, despite his difficulty receiving these notifications, Mr. Zambrano learned about the conference and read the scheduling order with sufficient time, about 2 weeks, well, maybe a week and a half, with sufficient time to request an adjournment if he was unable to attend the conference. Mr. Zambrano concedes that he learned of the November 6, 2024 conference and read the court scheduling order as early as October 24th. Zambrano declaration. They now pull up his own words against him. Further, Mr. Zambrano was aware of the court's individual rules, which advise parties that they may file letter requests for adjournments or extensions of time, which he never did. Therefore, Mr. Zambrano was aware that he could have sought relief from the court's order on account of his unavailability, but he did not do so. He did not take the relatively simple expedient of writing the court to request an adjournment, nor, it appears, did he ask his adversaries to request one on his behalf. Either of those alternatives would have spared the court and counsel for his adversary's time that was instead wasted. The court finds no circumstances that make an award of expenses unjust. Mr. Zambrano has offered no reason why imposing a sanction consistent with Rule 16F would be unjust. Mr. Zambrano has not claimed pecuniary hardship, and this court finds no other circumstance that makes imposing a sanction against him unjust. Jesus, they on your ass. He says, well, Mr. Zambrano has apologized to the court and all counsel for his mistake and for any inconvenience caused by same. Mr. Zambrano, Declaration 15, the consequences of his failure to follow the court's orders and to attend the scheduled conference or to simply take the time to write a letter to request that the court adjourn the conference are greater than mere inconvenience. That is because defendants pay for their attorney's time. It would be unjust for defendants to bear the expense of attorney fees for a conference for which plaintiff's counsel failed to appear or request adjournment without substantial justification. For these reasons, the court orders that consistent with Federal Code Civil P 16F, Mr. Zambrano pay the reasonable expenses incurred by defendants in appearing at the November 6th conference as ordered. Second Circuit proceeding requires that a party seeking an award of attorney's fees support its request with contemporaneous time records that show for each attorney the date, the hours expended, and the nature of the work done. Fee applications that do not contain such supporting data should be normally disallowed. District courts have considerable discretion in determining what constitutes a reasonable award of attorney's fees. The Second Circuit has directed that district courts should generally use the hourly rates employed in the district in which the reviewing court sits in calculating the presumptively reasonable fee. Those hourly rates are market rates prevailing in the community for similar services by lawyers of reasonably comparable skill, experience, and reputation. Therefore, defendants are directed to file by no later than December 2nd an application for an award of attorney fees accompanied by an affidavit of counsel and appropriate timesheets reflecting the total amount of fees and costs incurred by defendants in traveling to and attending the November 6th conference. So ordered. That means Megan and her legal team have until December 2nd to basically give the courts their description of their fees, the time, the hours, to find a reasonable price or reasonable fee that Mr. Zambrano and or Emilio would have to pay to Megan to cover her legal fees for the time they wasted. Okay? Wow. You're trying to sue me, and you and your team don't even show up. Ain't that about a B-notch? Whoa, whoa, whoa. And that document was filed today. Okay? Whew. Teflon Don in the courtroom, they said. I don't see any lies there. And I believe that the minimum, okay, Megan's lawyers are to file their attorney fee request no later than December 2nd. They said recently it's going to be in the ballpark of about $6,000. Not that Megan Thee Stallion needs $6,000, but of course, that money is going to her legal team rather than her paying them out of pocket or covering whatever she paid them out of pocket for a meaningless court date because the opposition never showed. So that's the latest in both of these cases. We may not get to Milagro until July of next year. There's going to be a lot going on in the between time. Milagro is not sitting silently. She's still attacking people on social media. She's still putting out smear campaigns against people on social media. I don't think this will be the last lawsuit aimed in her direction, to be honest. Emilio, you might want to take a picture of a new attorney because they finna have your ass in a world of trouble coming out of pocket and you ain't even getting to defend yourself or justify your own lawsuit. How embarrassing is that? Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I will catch y'all on the next one, all right? Much love and respect out. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rags. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mile. We finna do more than survive. I need my check. Spinning the block for the gouda, we hitting the jeweler to flood out the net. We don't do beef on computers, I'm straight out the sewer, we come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest, but drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some batteries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.